Hi, I'm Michael Oswald, a business guy who also happens to be a lawyer. And today I'm here to talk about the impact of the United States Justice Department filing an antitrust lawsuit against Google. That happened last week. The Justice Department is accusing Google of violating the antitrust laws by engaging in anti-competitive practices that have been illegal for over 100 years. So I'm here to help you understand what that potentially could mean for Google and for the internet ecosystem in general. So let me just tell you a little bit about the history of antitrust laws. In the late 1800s, there were four huge, one would call them conglomerates today, but back then they were called trusts. There was Standard Oil, there was United States Steel, there was a railroad trust, and a sugar trust. These four big conglomerates monopolized those very important markets. So the rich got richer and the consumers suffered because there was no incentive for any kind of innovation or improvement that competition generally brings. In 1890, Congress passed the Sherman Act, making it illegal to engage in anti-competitive practices such as price fixing. And in 1914, they added the Clayton Act and the Federal Trade Commission Act to sort of fill in some gaps that had been there since the Sherman Act got passed. Together, those three devices give the federal government a pretty hefty toolkit to use to go after monopolists. So there were even some potentially criminal penalties, although most of the antitrust actions involve civil penalties and also court orders to break up monopolies. There were big cases against AT&T in 1974 because they were monopolizing the market for long-distance services. The Justice Department won, and the court ordered Ma Bell, so to speak, to sell their Bell regional operating companies, and the Bell regional operating companies were then able to compete for long-distance services and not just providing the local plain old telephone services. If the Justice Department hadn't gone after them back in 1974, I think there's a decent chance we might still be using copper wire, getting the long distance from AT&T, Ma Bell, which was the phone company out in Pacific Bell, a phone company in California when I grew up, would still be providing lousy old service, and there probably wouldn't even be an internet, let alone all of the creativity we see from people like Verizon Wireless.
Yeah. Now, what's interesting is from a comparison standpoint.
Yeah.
From that, obviously we've seen that once you were to break up Pac Bell and now be able to, with the benefit of hindsight, 30 plus years later, be able to look back and say, okay, obviously that was a good decision. Are there other points, or how can we kind of tie these threads together and see how that has been a positive effect and why that should continue to be a positive effect?
Yeah. So again, underscoring the purpose of the antitrust laws, they exist to protect consumers and competition. They're not there necessarily to benefit a given competitor, but competitors do benefit in sort of an ancillary way by the government focusing on making sure that innovation and competition are allowed to take place. I said if AT&T hadn't been challenged back then, I don't think we would have seen anywhere near the kind of innovation that we have seen in mobile communication, for example. I don't think there would be a Verizon Wireless or an AT&T Wireless. I don't think there would have been the invention of the iPhone. I'm not sure that the internet would ever have gotten off the ground. And speaking of the internet, another famous case that the Justice Department brought in 1998 was against Microsoft, who was monopolizing web browser. So they had Microsoft was lost the case, and so they had to stop using their monopoly power to force people to play ball their way or not be allowed to use their web browser at all. So now Google is, they were a scrappy little startup 20 years ago when they thought they described themselves as the turnstile to the internet. Well, that scrappy little competitor is long gone. They're a $1 trillion market cap, 160 billion in annual revenues, and they are engaging in the same kinds of anti-competitive practices that AT&T was using, the same that Microsoft was using. Xerox was another case that the Justice Department brought back when I was in law school in the late 70s. Xerox was the dominant player in photocopiers back then. They were guilty of a practice known as tying. They required their users to purchase their inferior paper and toner and ink or be forced to be declared in breach of contract and have to give the photocopier back to Xerox. So anytime somebody who's is the 800-pound gorilla in a particular market, then it's very easy for them to throttle competition. And competition is what brings creativity. Competition is what encourages venture capitalists to fund competing startups. The complaint that I read from the Justice Department indicated that they spoke with venture capitalists who refuse to fund any kind of a business model that looks like it might be competitive with Google because they know that Google will squash them.
Now, can you speak to, there are competitors in the marketplace. Google isn't the only search. There's obviously Mozilla, Firefox, there's DuckDuckGo, and at least a handful of other search browsers you can use. What is it that specifically makes this, if there is competition in out in the marketplace, what is the issue there?
Google now has about 95% of the search market. So even though there are competitors in name, they are the de facto search engine. There is nobody who has a ghost of a chance of raising enough money to go after what else they would have to do to gain an appreciable amount of market share. So I think the Justice Department has a decent chance of prevailing, and one possible result, if they do win this lawsuit, is Google would have to break up their search into smaller pieces that other people could then innovate and compete against. That's I think a very foreseeable outcome if the Justice Department wins this lawsuit.
And what would you say to the argument that maybe is Google just that much better than everyone else? Do they provide just that superior of a product that everyone uses them, or what's?
Well, that was certainly what Standard Oil was arguing back in the late 1800s. That didn't carry any weight. Congress passed these laws to prevent companies that have dominant market share. It's very difficult for anybody to come up with a product that is so good that it gains 95% market share and is able to stave off all of the other competitors if it is truly a level playing field. As the Justice Department described in excruciating detail in that 66-page complaint that I read so you don't have to. They described the anti-competitive practices that Google has been using ever since they acquired the Android operating system in 2005, and then made that open source, and then used that as sort of a Trojan horse to get people hooked on the Android operating system, but then requiring device manufacturers, computer manufacturers, to install only the Google Play app, install only the Chrome search, and those things. And in fact, on cell phones and laptops, the agreements that these device manufacturers have to sign with Google require them to not only make that the default, but also to make those Google products uninstall and make them not removable. Stumbling over, but basically the consumer, even if the consumer wanted something else, has no choice. There's no way for me to take the Google Play off of the Android phone that I have.
Interesting. Now, because Google offers their own phone, even there's the Google phone, Google Pixel, or whatever it is.
Yeah.
What is the really kind of at the heart, if we were to kind of tie the strings together of what the case is, what, just kind of in summation, do you think is the real issue that Google's facing going forward? What do you think some of the possible outcomes might be if that were if the Justice Department wins the case?
Yeah. So I could see them, the Justice Department, asking the court to order, and the court agreeing to order Google to be broken up into a lot of small players and sold off to other, so that who would then be required by the Justice Department to not engage in any combinations of any of those little pieces, so that you put Google back together 20 years later. The Justice Department's pretty good at coming up with these agreements that say, okay, we're going to break. I think it's actually, Google is one of, I don't know, 6 or 7 or something companies that are all part of Alphabet Inc. Alphabet Inc. And I could see the Justice Department taking the A, the B, the C, the D, the E, and making them all go in totally different ways, so that you couldn't put Humpty Dumpty back together again.
Interesting. Is that a concern, or has that been tried in the past, to your knowledge?
Yeah.
Ah, gotcha. So they're used to the end around from
yes,
from that standpoint.
Yeah. In fact, that's why the Clayton Act had to be passed in 1914. The Sherman Act, passed in 1890, left open a bunch of opportunities for people to, instead of forming one giant trust, they started merging 3 or 4 or 5 companies together and forming the functional equivalent of one of the old giant trusts. Oh. So that's why the Clayton Act was passed in 1914. And so it's the Sherman Act that the Justice Department is invoking right now, but they could certainly amend the complaint to allege Clayton Act violations as this case goes on.
Oh, interesting. So you think that there's potential that there's been more than just the one breach, so to speak?
Yeah. Yes, I do.
Interesting. Now, is there any other thoughts, kind of just in summation of the case, or anything going forward that you want to keep an eye on?
Yeah, I think after Google files their answer, it'd probably be good for me to come back and have another conversation with you, and so I can tell you what Google says are its reasons that they actually are complying with the antitrust laws. So I will keep an eye on that, and I'll let you know.
Gotcha. Perfect. Well, thank you for being here, and thank you for reading that brief so we didn't have to.
You're welcome.
We'll follow back up with you as this case moves forward.
Very good.